Hello, everyone. I'm Charina Garcia, and thank you for joining our webinar today titled Alternatives to H-1B. We will be sharing the PowerPoint and then also recording after. If you have any questions, we ask that you put them in the Q&A section, and we'll have some time left at the end to answer those questions. You can also go on our website and also watch this again on our YouTube channel. We can go to the next slide. So just a legal disclaimer, of course, everything we provide is not legal advice. It's for informational purposes only. We welcome you to contact us and schedule a consultation if you'd like to hear more about the options we discussed today. And then just about our firm, WR Immigration is exclusively U.S. and global immigration firm. We have 9 offices and around 200 professionals. And we welcome you to reach out to us if you want any more information about the services we provide. And next slide. One of the great features we have is our technology tool called Rapid. And if you would like to get a demo on that, we welcome you to also reach out to us. It's a great management software that we use to ensure that clients are kept apprised of what's going on and full transparency and reporting. And again, I'm Charina Garcia. I'm the managing partner here in the San Francisco Bay Area. I handle US-based immigration. And I'd like to introduce you to Audrey, and she can give her own introduction about her background as well.
Thanks so much, Charina. I'm Audrey Lustgarten. I'm the global partner at WR Immigration. And so that means that my team and I cover the rest of the world, about 100 countries worldwide where we provide employment-based immigration services. So here to talk about some of those options if the US is not working out. Back to you, Charina.
Thanks, Audrey. Audrey and I have been working together for a long time, I think at least 10 years or so. So we know each other really well. So I'm really excited to do this with her. So the topics today are the US options. Then we're going to talk about the global options. And of course, we'll have some time for questions at the end. So I want to first start it off with non-immigrant work visas. So the whole purpose behind this webinar was because the H-1B cap was reached and there was a lottery run, and it was reached rather quickly. The day they ran the lottery was the day it was reached. And so they started sending selection notice to those who were registered, and those who were not registered are still held in a queue in a waiting pattern. And basically what the Immigration Service does is you're allowed to submit your application until June 30th. After June 30th, they see how many applications they've received. If they haven't received enough to hit the cap based on the selection, then they'll hold a second lottery. Last year, there was no second lottery, but the years before there were. This year, I want to say the selection rate was about 20% and maybe a little bit higher if there were US master's degree holders. So we're doing a lot of consultations right now about what are the options for people who are not selected in the lottery. So we can go to the next slide. So now it's been met, now what? So the other H-1B cap that it's available is the H-1B cap for exempt organizations. So these are universities, institutions of higher education like colleges, or nonprofit organizations that are affiliated with an institution of higher education. There's also nonprofit research organizations and government research organizations. Those organizations don't ever have to worry about the H-1B cap because they can file an H-1B at any time. Some of our clients will actually work for a nonprofit research organization and also work for a private organization that would be subject to the cap. So the basic premise is if you have an H-1B and you are cap exempt and you're working with a nonprofit research organization, and you're working for a private company like part-time, then you can actually work for both and you won't be subject to the cap, okay? So, but if you decide to stop working at that nonprofit research organization, then you would be subject to the cap and you'd have to go into the lottery the following year. So I think it's important that people know that there are nonprofit organizations out there that do offer this service. I believe there are a lot of fees associated with it, but if you're interested in that option, I believe there are some nonprofit organizations that actually provide the concurrent H-1B option. We can go to the next slide. So the other visas that you would look at are basically based on free trade agreements. So there are certain countries that the US has trade agreements with. The countries have negotiated that their citizens can seek specific work permits in the United States. So Chilean and Singaporean citizens are eligible for what's called the H-1B one. It's an 18-month visa. It is subject to a cap, but it's never reached. So, you know, that's a good option. There is, of course, the TN for Canadians and Mexicans. There is a list of professions that is permissible under that category for the TN. For Canadians, they can apply directly at the port of entry. So that could be at the border or, you know, with the USCIS. And then Mexican citizens must apply at the US consulate or embassy. And then there's the E3 visas for Australian professionals. And then there are also E-visas for people from certain countries who have a specific trade or investor visa option with the United States. So for example, Japan, UK. So if you have a company that's at least 50% owned by a UK company in the US, and you have a UK national that you would like to employ in a managerial, executive, or specialized knowledge capacity, you can actually obtain an E visa for them. And then, of course, we have the dependent work authorization. So these are individuals who are actually dependents on someone who's on an H-1B, a J-1, an L-1, an E. And so those visas are really based on the principal's ability to stay in the US. So the H-4 EAD is based on the spouse's H-1B status, and that the spouse is at a certain position in the green card process or has hit a certain milestone, and then that individual can get an H-4 EAD. And it is renewable based on how often the principal can renew the H-1B. For the L2 or E status dependents, they actually don't have to apply for a separate work authorization. As long as you have an I-94 that is annotated, you can actually use that to start working in the United States. So work permit's no longer required. But for J2s, you do still need a work permit. And then, of course, we have the O1 visa of extraordinary ability. Lots of people feel they qualify for this. So, you know, it is really for the top individuals in their field, and it does require a lot of documentation. So we would prepare and provide to the Immigration Service awards, you know, if they've been cited, their Google Scholar citations, any articles about them, any articles about the work they will be doing. And these O1s are great alternatives if your individual can meet it. You know, having a PhD doesn't necessarily mean you can qualify for an O1. We really need to look at the whole package and see what other items they have that would make them qualify. It is valid for 3 years and renewable indefinitely. And it can be premium processed. So this is a good option if if the person qualifies. And then, of course, we have a lot of F1 students who are on OPT, STEM OPT, and unfortunately, they're running out of OPT time. And so what can they do? Well, you know, based on the prior slides, you know, they may be able to qualify for an E3, a TN, but many times they can't. And so what are the other options for them? Well, if they are back in school, like they re-enrolled in school, or they can also get severe economic hardship work permit. This is really difficult to get. It really depends upon what's going on in your home country or certain conditions that have caused you to require you to get work authorization in the US. There is the most popular curricular practical training, or what we call CPT, where many students who have completed their STEM OPT will ask me whether they can pursue an additional coursework where the school will offer CPT. The requirement is that the student has to be going to school for part-time or full-time basis. They have a signed cooperative agreement or letter from the employer, and it has to relate directly to the major of study. And how the CPT is granted is through what we call an I-20. Now, these are really, you have to be really careful with these, because a lot of the schools that actually offer CPT are under scrutiny by the Immigration Service. So my recommendation is never to recommend any particular school. Whenever someone asks me, I say I have no, you should look on the internet or you should talk to friends, but there are no particular schools that I would recommend, because we have seen RFEs where they're questioning the legitimacy of the CPT. And then if your individual is coming here and wants to do training, and you have a set training program, and some companies actually have this, where you're actually bringing people from overseas to come in and receive training specific to your organization and what you do, and this training can't be found in the home country, then you can actually bring these individuals in on a 2-year training program. It is a great process, because you can just file one petition for as many trainees as you want, but it is also scrutinized a lot by the Immigration Service. They really want to make sure this is not on-the-job training, that this person really is sitting in a classroom and has a whole curriculum of what they're going to be learning and being trained on while they're here in the US. And then there's, of course, the J-1 visa. So if you have researchers that want to come to the US, there's this program called the Early Career STEM Research Initiative that's encouraging people from overseas to come to the US as research scholars. So you would go through a program sponsor. There's also the trainee visa, where they can come in for 18 months. The requirement is they have to have a foreign degree, and they have to have at least 1 year of related work experience outside of the US. If they have a US degree and no foreign degree, they will not qualify. So many of these people who are in STEM OPT, they don't qualify for the trainee. They have to have 5 years of related work experience outside of the US if they don't have a foreign degree and 1 year of related work experience. We have been able to get some folks from STEM OPT to the research scholar, but it really depends on the work they're doing and the research they're doing. And then if you have fresh grads from overseas, or people that are actually in school and want to intern, they can come in for a 12-month period. They have to be enrolled in school or have not graduated for more than a year from when the training period starts. One caveat to the J-1 visa, just really need to be careful about the skills list. If the individual is coming here, and let's say the Philippines requires this electrical engineering experience to be brought back to the Philippines, then they will have a 2-year home residency requirement. Sometimes this can be waived, but just be careful when you're pursuing the J-1 visa. And then this one has been coming up a lot. I get a lot of questions about this, the compelling circumstances EAD. So the USCIS actually, you look at the bottom, there's a site there, and they actually, with a lot of the layoffs that have been happening, and folks who may have been on L1 and have used up their L1 time, and they can't get on H1 and they have to go home. Sometimes this is an option, and it's issued in 1-year increments, and it's renewable yearly. So basically you have to be the beneficiary of an approved I-140. You have to be in the US in E3, H-1B, H-1B1, O1, or L1, non-immigrant status. So this would apply to our L1 folks who couldn't get the H-1B lottery. You can't file your adjustment because your visa number is not available, and you have compelling circumstances that justify you to be able to get this employment authorization. Now, the website lists some of these examples: serious illness or disability faced by the worker or their dependent, employer retaliation, other substantial harm, and significant disruption to the employer. But I do have to tell you, this is a very, very high standard. And there are very limited compelling circumstance EAD that we've seen approved. The other caveat is they're no longer in any status, so they're not going to be on H1 or L1, so they basically have no status. So when the adjustment becomes available, they may not be able to adjust. So these really are just temporary work permits. And then now let's talk about the green card, right? So this is immigrant visa. And just to give you the process, it's 2 stages. So the employer typically, or your family member or yourself, will file an immigrant visa, and that's the basis to immigrate in the US. And then you can either do adjustment of status or consular processing. So you can process your green card here or overseas. And then there can be backlogs on this stage of how long people wait from the immigrant visa to the adjustment of status or consular processing. We can go to the next slide. So the green card lottery. A lottery is run every year for individuals who are from certain countries that have a very low immigration rate to the United States. And this typically happens in October. There's no fee to apply, so anyone who can apply should apply, and the family member should apply too. If you go to a website and they ask for a fee, you should always just go to the Department of State website, only that site. There's a lot of fraudulent sites out there. But unfortunately, if you're from countries where there's a high immigration rate, like Canada, UK, India, Mexico, Philippines, unfortunately, you're not able to qualify for this diversity lottery. And it is based on the country of birth. So if you have a spouse who's born in Japan, but you are born in the Philippines, your spouse would be able to apply under the diversity lottery. Now, I talked about how there's waiting periods when you file the petition. And so, this is the visa bulletin for April 2023. If you want to learn more about the visa bulletin, you should watch my Chatting with Charlie webinar series that I hold once a month. But this is just an idea of how long does it take, right? If I am the brother or sister of someone born in the Philippines, right? They're processing, August 22nd, 2002 cases. That is a long time. That's like 20 years, right, to get a green card. So if your person hasn't won the H-1B lottery, what are some of the options? Well, there's family-based, but it's still quite a wait, right? The F2A are married spouses of green card holders, and there's still about a 2-year wait. And then there's, of course, the employment-based. So I'm going to talk about the self-sponsored EB1, which if you see the letter C, it means it's current. But if you see people born in China and India, there is still a wait, right? So even if they get through the first part of the process, they still have to sit there and wait for their number to be called, which could be anywhere from 6 years to 10 years to 12 years, depending upon where you're born. We can go to the next slide. Okay, so I talked about the family-based green cards. Now, if you want to stay in the US and you're running out of time and you're already here and you didn't get the H-1B, of course, everybody says marriage, right? Marriage to a US citizen is always the fastest route. I agree, it will allow you to stay here. Usually it's about a 12 to 18 month processing time. And then there's all the other categories, but those take a long time because look at them, 8-year backlog, 2 to 3 year wait, 15 plus years, and then 16 plus years. So really, those aren't really good alternatives if you want to immigrate to the US right away, and you didn't get the H-1B. But I leave that out there just so you can see what some of the options are if you have family-based petitions. Next slide. So employment-based, so the EB1, the nice thing about the EB1 category is that you can usually apply for it and then apply for your green card at the same time, as long as your number's available. The EB1A, if you had to think about ranking like 1, 2, 3, so EB1A is the highest category, and that's for individuals of extraordinary ability. It can be self-sponsored, very high standard, certain criteria you have to meet, and the government does do a final merits determination, meaning even if you meet all the criteria, 1, 2, 3, 4, 5, they will look at it as a whole and they could still determine you don't qualify. There's also outstanding professors, 3 years of research experience, and then international recognition. That one requires a sponsor, so you do need an employer to sponsor you. And then multinational managers and executives also requires a sponsor. You worked abroad for a company for at least 1 year as a manager, and you're being transferred here to be a manager as well. And then the self-sponsored green card. This is very popular now, what we call the national interest waiver. This one does not need a sponsor. You can self-sponsor if you're under the EB2 category and your date's current, then you can also apply for your green card at the same time. This is a 3-pronged test. Work has substantial merit and national importance. Your position to advance the endeavor, and it would be beneficial to the US to waive the requirement. So we do a lot of these. If you'd like a consultation on whether you qualify for EB2 or if your employee qualifies, please reach out to us. And then there's the other process, which we call the PERM. And this is where you test the labor market, prove you can't find a US worker. And depending upon the qualifications, it would either be an EB2 or an EB3. Now this category, if we go to the next slide, you have to do a test of the labor market. You have to get a prevailing wage. So this process realistically takes about a year before we can file the labor certification. And then it'll probably take another year, year and a half, for them to get their green card, depending upon where they're from. So if you have individuals who are overseas and they didn't get the H-1B lottery, and they're born in a country like the UK or Japan that doesn't have a quota weight, this actually could be a good option. So instead of putting them into the H-1B cap each year, you just go straight to green card and you just sponsor them. And then they process their green card abroad. And then our firm actually specializes in the EB5 investment green card. If you're lucky enough to have a high net worth and you want to be able to invest in a business in the US or a project, then you would be able to get a green card as well too. So I ran through most of those really quickly, and we can go to the next slide. The number one question I get is, Charina, they didn't make it in the lottery. They've run out of time. Can we send them to their home country to work remotely? And can we keep them on the US payroll? Okay, that's a question I always get, right? I will always answer yes, you can keep them on the US payroll, but you need to check the tax and employment law consequences in the country that they are residing in. And you also need to think about, all the challenges of that. Like, are they going to have access to your internet? What is the security protocols there in their home country? So it is possible. Some companies will actually put their individuals on an international professional employment, organization where they pay the salary on behalf of the company, but it is very expensive. Audrey, anything else you want to share about this option?
Yeah, just to be cognizant if there are any other ancillary immigration challenges of going home again. I mean, if they've become married while they were away to someone from a different country, that can be tricky. Children born outside the home country can be tricky. And every once in a while, we run into a country that actually does require some registrations and some paperwork to even just to come home again as a citizen of that country. So it can be challenging.
Thanks. So that's my bit about the US side. So we're going to have Audrey now talk about the global options.
Great. Thanks so much, Charina. And I always feel really lucky when I get to talk about the global options after the US options, because the US, I have to say, and I deal with about 100 countries around the world, is by far the most complex and difficult immigration system out there. There are a few others that come close. I mean, Australia comes to mind. But the US takes the cake with regard to complexity and difficulty for our poor clients that are struggling through and really trying to find options to bring in the talent they need to keep their businesses running. So we can go to the next slide. This time of year particularly, I tend to get a lot of inquiries from anxious companies and individuals wanting to know what on earth they can do if they're not selected in the H-1B lottery, where they can go. Frequently people start just Googling lists of countries and coming up with all sorts of ideas. And I really encourage, as the first step, when you realize, okay, the US is maybe not going to work out, but this person is someone we really need in our business. We want to retain. What on earth can we do? Is to stop and do a strategic assessment before you dive into the internet research of, what countries might be appealing, because that will save you really a lot of time in the long run if you take a moment to do kind of a strategic assessment. And in that assessment, we always look with clients at the push factors and the pull factors. So the push factors would be, identifying the requirements that a country would have to meet to really be a viable option for you. Since we are talking in the context of US immigration here, looking at the purpose of the transfer, many clients are looking to send someone out of the US for a period of time so that they can, kind of park them there and hopefully bring them back to the US because that's where they're really needed long term. So is that what you're trying to accomplish with this global destination? Or is it really that you just want to retain this employee and place them in, another one of your entities overseas on a long-term basis, and you're happy with that, and the employee's happy with that, and the end goal is not necessarily getting them back to the US? And I ask that because that will drive what options are really viable. Some of the options I'm going to talk about will not lead to your ability to, for example, transfer the employee back in a year on an L1, either as a manager or as a specialized knowledge personnel. The second thing, obviously, you want to look at the business needs. Where in the world is the business willing to have this person and continue to employ them? Canada may be a perfectly acceptable option, same or similar time zone, very close proximity for business trips back to the US if needed. But by the same token, maybe the UK isn't. That 5-hour time difference is just going to make it not viable. The person will not be able to meet the business's needs. So it doesn't make sense to then start exploring countries that are, 4, 5, 6, 7 hours time difference from where the rest of the team may be based in the US. And then, of course, the employees' needs and wants matter. Where in the world are they willing to go? Maybe they're willing to go to Canada and, the UK, but Mexico, not so much. They don't speak Spanish. It's not as appealing for them. Their spouse may have, needs in terms of their employment. They may have children. Where are they able to get adequate schooling? So things like that, really, the purpose of the transfer, the business needs and the employee needs will help you to identify what a country would have to really be a viable option. And then on the flip side, the pull factors. If you look at countries, identify countries that are most likely to offer a viable immigration option, the path to going global will be much easier versus just pulling out countries that look attractive, but there's no particular connection there. You might not be able to actually get the person a visa or a permit. So I always suggest starting with countries where the company has an office already. That's going to make everyone's life easier. You'll have an existing structure there. A lot of the immigration options I'm going to talk about require a company in that country to sponsor, the work permit or visa. So that's a starting point. If you have offices outside of the United States, start off by looking at those countries as the primary options for where you might want to place someone who wasn't selected in the H-1B lottery. Next would be looking at countries where the employee has a particular connection. Maybe they have family in that country, or they have ancestry. Some of the European jurisdictions, you can actually get citizenship based on ancestry. So it can open up additional options from an immigration perspective. And then last but not least is, one silver lining of the pandemic is that we now have a lot of countries that offer flexible digital nomad type visas where you don't have to have a company office location and the employee doesn't have to have family or some other connection in order to be able to access that visa. But certainly, as much as those are in the news, not every country has that. So you'll want to narrow down to the countries that do if you want to consider that option. All right. So starting off with Canada, because this is always the country we get the most questions about, it's at the top of everyone's list because it's so close to the US, English language, quality of life is good. It's a little bit cold, but other than that, pretty nice place to live. But it can really present some significant challenges, even though it has a reputation as an immigrant-friendly destination, business-friendly destination. It's not as easy as you might think to just pop across the border and park one of your employees there, so to speak. The most common challenges that we run into when we get those calls from clients saying, okay, well, they can't stay in the US, they're going to Canada, is that you need a Canadian entity to sponsor the work permit, often with a physical location. For most of the permit types we're going to talk about. So it's not simply, the person can go across and self-sponsor and live and work in Canada. If your company doesn't already have a Canadian entity, ideally with a physical location, it's going to be an uphill battle to get one of your US employees transferred over to Canada. Second on this list is that it has to be a bona fide Canadian position benefiting the Canadian entity in some way, shape, or form. This can't be, what we get all the time is I'm just going to go sit in Canada and perform my US job remotely. Well, of course, when we go to the Canadian government and request a work permit, if we put in the work permit application, the US rejected us and, we just want to perform our US job remotely because Canada's really friendly and lovely, we're going to get a rejection. You have to have some sort of real reason, like a pull factor from Canada for needing to place this person here. It doesn't have to be, Canadian immigration tends to be fairly reasonable, but so it doesn't have to be that 100% of their duties will benefit Canada all the time. Like they understand that there might be some international duties involved. You might be responsible, for example, manager might be responsible for some portion of operations in North America, so Mexico, US, and Canada. That's okay. But I'm just going to do my US job remotely from Canada argument doesn't get us very far, unfortunately. Another sometimes unpleasant surprise is that the definition of a criminal record in Canada for immigration purposes includes DUIs. Even very old DUIs. So it's really important, as uncomfortable as it can be, to screen for this early on when you're considering options, because if the employee does have a criminal record, even just, a DUI from 5, 10, 15, 30 sometimes years ago, it can pose a problem. If it's a single offense and it's very old, it's usually something that can be overcome, but it is extra paperwork, extra application process to go through. And if it's more recent or there are multiple offenses, then it can be a complete bar to them being able to relocate to Canada. And then the last thing that is a challenge for Canada is, just the processing times for visa nationals. So similar to what Charina was mentioning on the US side, like the US, Canada does have some instances where you can apply at the port of entry. So for US citizens, obviously we get some preferential treatment, but citizens of other countries that are, visa waiver, they don't need a visa to visit Canada. If that's the case and they're coming in and getting a Canadian work permit, they can actually turn up at the land border or at the airport and apply for their work permit on the spot. They've obviously got to have a well put together application package. They should not just turn up without preparation. But if they have, a strong work permit application, they can just turn it in there and be issued the work permit on the spot. The challenge comes with visa nationals, and things are, thank goodness, starting to get much better. But throughout COVID, we saw really large backlogs. So for those that did have to go to a Canadian consulate and apply for their work visas, they couldn't just go to the port of entry. I think the worst that I saw it got up to about 45 weeks processing in India, which was quite a long time to wait. Again, those have gotten much better in most locations, so not seeing quite as many challenges there. Next slide. So because Canada is such a destination of interest, I'm going to go through kind of some of the common work permit categories here, because we really get a lot of questions around those. Everyone's trying to figure out, can I fit my employee who was not selected for US H-1B into one of these categories? There are some good options out there, depending on whether the person has already worked for you for at least a year. The intercompany transfer work permit option, which is really similar to the US L1, is often a viable option. And that's really nice because it's a really quick option in most cases, and really pretty easy to get if you fulfill the minimum criteria. The main things you're going to have to look at when considering whether this might be an option is do you have a Canadian company with a physical location to sponsor this person? That is required. You have to have a company to transfer them to in order for this to work. The person must have been employed with the same corporate group of companies for at least 1 year within the past 3 years. They must be currently employed, and it has to be in a managerial or a specialized knowledge role. I will say, as compared, some people hear the term specialized knowledge and I think they have PTSD from the US side, where this can be very, very difficult to prove. Not to say that Canada is easy, but the standard for specialized knowledge in Canada, in my opinion, is much more reasonable and business friendly than maybe it may be on this side of the border. So it is a viable option for an awful lot of people. They've got to be going into kind of a similar role, showing that they're qualified for that role. And then there are wage requirements based on the occupation and the location within Canada. Somewhat similar to the US side, you're not actually having to apply for prevailing wage determinations like you do in some US applications. It's really just looking at the published wages from the government based on the occupational code, and where in Canada, obviously the cities are more going to have, higher wages in Toronto and Vancouver than you would in some of the more rural areas. Really nice thing, if your employee is eligible for the intercompany transfer work permit, their family can go with them, and their spouse is eligible for an open work permit. They can get theirs at the same time as the employee, so no waiting there, and that allows them to work for pretty much any employer of their choosing with very few restrictions in Canada. So that is really nice. The maximum duration, again, mirroring some of the US rules, 5 years for specialized knowledge folks or 7 years for managerial. The permits are usually granted for 3 years initially, and then you can renew them. Next slide. Another really good option if the employee happens to be a Mexican citizen, or of course, if you're dealing with a US citizen, but then we wouldn't be talking about the H-1B. But for Mexican citizens, similar to the US side, where it's called the TN, in Canada, they have the Kusmabased work permit based off of the Canada-United States-Mexico agreement. And this allows folks who are in certain professions, which are listed in that same appendix that we heard about earlier, the same list of professions, to go to Canada without having to qualify for an intercompany transfer. They've got to be holding the relevant qualifications that are also listed in that appendix. And the best thing I think about this is that you do not have to have a Canadian entity to sponsor the worker. So this provides quite a bit of flexibility. They allow it to be a US or Mexican employer if there is some connection to Canada. So you can't entirely get away with, I'm going to go to Canada and perform my US job remotely still, not a go on that. But if you have contracts with Canadian companies, if you have a reason that you can demonstrate that the individual needs to be working in Canada, apart from their US immigration troubles, you can potentially, as a US company, without having to set up a Canadian entity, go ahead and get them a Kusma-based work permit. The process is really nice and simple. It's a port of entry application. So again, presenting it at the border, presenting it at the airport, family can go with you. The spouse is eligible for an open work permit. The permit is granted for up to 3 years, and it's renewable indefinitely. So there's not a max out date that you have to worry about with this option. Next slide. Now we're getting into some of the more difficult. I'm kind of going in the order from the ones we hope work to the ones that are more creative or more difficult options. Canada has something called the Labor Market Impact Assessment based work permit. And this basically, it's like a mini PERM. You have to test the labor market to show that there is not a qualified Canadian citizen or permanent resident available to fill the role. It's a 4-week test of the labor market. It is quite a bit of work on the company side. But if you have roles where it is legitimately difficult to fill, it is something that can be viable if the company is willing to put in the work of going through the labor market testing. You do, though, need the Canadian company already set up to be able to sponsor the individual. Next slide. There is also an expedited version of the labor market impact-based work permit under the global talent stream. And this is, again, you do need a Canadian company to sponsor. It is for select occupations only. We provided a link to the list there. The nice thing about this is that instead of having to do that labor market test and show that there are no Canadians available to fill the role, the company instead commits to undertaking some efforts to benefit the Canadian labor market more generally. And this can be, there's a whole menu of options, increasing the number of Canadians, establishing educational partnerships or internships, initiatives to increase underrepresented groups. The idea is basically that you are willing to make a contribution to Canada, and in return for that, they allow you to skip the labor market test. And they also offer expedited processing of the LMI application, which is really nice. So this can be, once you get it set up, can be quite a nice, quick option to get people to Canada. Obviously, assuming they don't qualify for the Kusma or the ICT, I still think that those are a bit easier. Next slide. And finally, permanent residence in Canada looks a bit different than it does in the US. It doesn't require a sponsor, a company sponsor. There's no PERM, there's no labor market test. Instead, it's a competitive points-based system based on kind of the individual's qualifications and attributes, and not necessarily on who they're going to be employed by. So people can go and apply for this on their own. And I think many people who are not selected in the US for H-1B do look to this because it's something they can do without having to find a job, without having to have a company there able to sponsor them. And then if they do ultimately succeed in getting to Canada as permanent residents, then they have a lot more flexibility. They can do a remote work job for their US role. But the trick here is timing. It's a slow process. You're looking at usually at least 12 months to go through the various steps of the process. Next slide. So after people finish asking about Canada, usually they go to Mexico. Mexico is also a good option if it meets the employees' needs and the business needs. The immigration system there is really quite business friendly. There are two options we look at. One is the traditional work permit sponsored by a Mexican company. This requires a physical office location. You're hiring the person locally on Mexican payroll. So you do need that structure already in place. If you don't have an office in Mexico, then it wouldn't really be a viable option. But if you do, it can be really nice because beyond those factors, the government really allows the company to determine who they're going to hire and who's qualified. They're not looking at the educational background or years of experience. There's no labor market testing. It's basically if the company is happy with hiring this person and can meet the minimum requirements in terms of, putting them on Mexican payroll with a Mexican entity, the government is happy to grant the work permit. The timing can vary by location within Mexico where the person is going to work, but it's fairly reasonable, usually around 30 days. For the work permit application and about a week for a visa stamping. So it's pretty fast, straightforward option. Next slide. The other option in Mexico is the non-lucrative temporary residence visa, and this is really for remote work. This is if you don't have an entity in Mexico, you can temporarily park the person in Mexico, so to speak. The employee must remain employed and paid outside of Mexico, so they're not actually permitted to go on local Mexican payroll on this type. And they have to show their own financial means in the form of either salary. I've got the numbers up here, the monthly salary or a bank account balance. And they have to be in legal status in the US when they apply. So it is a timing game. You have to make sure that you are filing this application well in advance of, when they're going to run out of legal status in the US. The trick here is that, and Charina and the US team can speak to this further, but if you're putting someone in a remote work situation, they're not really going to be, accruing time to return to the US on an L1. So that's why it's important to know what your long-term strategy for this person is. It gives them a nice option, to be in Mexico, to be legally working in Mexico, but they're individually, working remotely, not accruing time to come back. One flag for Mexico with the non-lucrative temporary residence is that we have had clients encounter tax challenges. So we always encourage folks to vet the tax consequences of remote work as well. Next slide. And the UK is another really popular option with a lot of our clients. It's a business hub where a lot of US companies have offices already. There are a lot of different options in the UK. The two I want to just touch on here quickly are the high potential visa for graduates of certain universities. This is a relatively new option, and it's really nice because it doesn't require the UK employer to sponsor the person, and it is very quick. UK processing, if you are willing to pay very high government fees for an expedite, you can get a visa in as little as 2 days often. Obviously, you have to prepare some documents in advance to be able to file a successful application, but you're looking at a very quick turnaround time. The catch is that there's a really limited list of schools. So the employee must have gone to a school that's on this list, and they must have graduated within the past 5 years. So it's really for recent grads of top schools. But if you've got one of those on your hands and you want to retain them, this could be a really good option to do so. Next slide. The most common type of work visa in the UK is a skilled worker visa. This is kind of the bread and butter of UK immigration. There were some changes post-Brexit that were really nice when this was introduced. It used to be very difficult to get UK work visas. You used to have to do a labor market test. It was really difficult. With the worker shortage, I think that they have been incentivized post-Brexit to make it a bit easier to bring in foreign talent. So right now, you do still need to have a UK entity there to sponsor them. And that entity needs to apply for something called a sponsor license, which is basically permission to sponsor foreign workers. It's a due diligence application that you go through with UK visas and immigration. It's quite detailed. You can actually look if you have an office in the UK and you're not sure if they're registered. I've included the link there so you can look it up. It's publicly available, which companies hold current sponsor licenses. If you don't have a license, but you have an entity already set up and are interested in learning more, pursuing that, definitely get in touch. It can be a little bit daunting if it's a newly established company because you have to show a lot of different things. Evidence of your office space, bank account, tax registrations, all those things you don't have necessarily on day one when you've set up a new entity. And the position, again, back to mirroring what Canada has, it does need to be a UK-based position. Just I want to do my US role remotely from the UK doesn't work here either. Next slide. Again, flagging the downside of the UK is it's very expensive, cost of living and government fees, but you can get the skilled worker visa valid for up to 5 years. It's renewable, and it's very straightforward to qualify for indefinite leave to remain, which is what they call permanent residence there after the 5 years of residence. So it's a nice option for those that qualify. Next slide. Last but not least, because this is where I've been wanting to go this winter, is the Bahamas. And I threw this in just as an example of a really convenient remote work destination that has a very accessible digital nomad type visa. They call their program BEATS, the Bahamas Extended Access Travel Stay Program. And literally, I think it might take you longer to find a hotel than to get a visa for you to go and work remotely in the Bahamas. So if you're in a situation where you just need to place an employee somewhere, again, not looking to accrue time to come back to the US on L1, but you just need to park them somewhere temporarily and you need to do it quickly, this might be worth considering. You basically have to have a valid passport, employment letter confirming your employment. You can't be on the Interpol list of wanted folks, and you're not allowed to be employed locally in the Bahamas. So you can't get hired and put on local payroll. If you satisfy those requirements, you too can work remotely from the Bahamas this coming year. And there are other programs out there as well. If for some reason the Bahamas doesn't work, there are many programs throughout the islands. There's a few in Europe that offer pretty easy access digital nomad visas. The downside is, of course, labor and employment tax, it can be a little tricky for the company. So you've really got to do your due diligence before your employee, celebrates their good luck in not being chosen in H-1B and gets on a plane to the Bahamas. So there's a little bit more to it than that, but at least the immigration part of it is really nice and straightforward.
So how long does the Bahamas one take? Audrey?
5 days usually.
Wow, 5 days. And then how long can they stay in the Bahamas?
It's a year. It's 12 months.
Oh, so 1 year.
Yeah.
Oh, not bad while you're trying to figure out where they go next.
Yeah, there are worse places to be stuck, for sure.
To be, yeah. Thanks, Audrey. So we're going to open up for questions, and we have some questions. So the big question is the PowerPoint available? Yes, it will be available. We will email it to everyone. And so just watch out for your email. And then the recording is also available. It'll be in our YouTube channel. And then we have some questions. Is there an E option for a company which is 100% owned by a German company? Yes, there definitely is. It's called the E-Visa, and it is only limited to individuals who are also German citizens. So they have to hold the same nationality as the foreign company. So yes, that is an option. Is there anything available for those in L2 status waiting for their work permit for nearly 1 year? The good news is L2s don't need a work permit anymore. Basically, if you exit the country and you re-enter and you have this annotation on your I-94 that you're here on L2S, you don't need a work permit. You can use that annotation to actually work at any company. It's open employment, so you don't need to wait for a work permit. There are some questions about people who have reached their 6 years on H-1B. So the rule is basically if you reach your 6 years, you have to exit the country physically for 1 year, and then you can register again in the H-1B lottery to get another fresh 6 years. And then this question, the person's now on O1 and they're selected in the lottery. Can they file the H-1B cap petition? No, because they weren't out of the country for more than 1 year. They have to be out of the country for more than 1 year. And they're working for a private institution. So it doesn't matter if you spent the 6 years with a nonprofit or a private institution. It is a maximum of 6 years on H-1B. Then you have to leave and be out of the country for a year, and then you can put yourself back into the lottery through your employer. And then questions. We have one more. Let's see. What's the other question? Let me read. Okay. I have an employee on F1 visa that we're sponsoring for permanent residency. So this is a Chinese national. What happens when their I-140 gets approved? Do they still have to maintain their student status in order to maintain their legal work status? The big answer to that is yes. The mere fact that you have an I-140 approved or PERM approved does not mean you can legally stay in this country. You need to have some sort of underlying status, whether it be an F1, an L1, an E3, or something like that. You can't simply just stay here because you have an approved I-140. That's just a process to get you along the green card stage, but it doesn't grant you work authorization to stay here in the US. And then I think we have one more question. As USCIS have reported multiple times, individual petitioner files multiple lottery through various consultancies. Does Immigration First aware of such loopholes? We have heard of them. To be honest with you, I have had clients who I've had to tell them, unfortunately, your employee was not selected. And then they come back and they say, well, actually, they got an H-1B number through this consulting agency. So can we hire them through the consulting agency? And I say, no, that's not allowed. That's gaming the system. And let me tell you this. If the consulting company hires this individual and then they work at your company and then you turn around and you file an H-1B change of employer, it will be denied, okay? And there will be a notice of intent to revoke the first one because you're basically gaming the system, right? And so we don't allow that. We have we explain this to our clients that that's not allowed. And so you just have to be really careful with people who hold an H-1B number and they don't even work for the H-1B employer on October 1. You know, the Immigration Service is really looking at all of that because that's a common pattern that's happening right now. I mean, the entry to get a registration is $10, right? So what's stopping, you know, consulting agencies or different companies from entering one person in a lottery for 5 different organizations, right? So we're seeing that. We don't know yet how many people applied, but last year was almost 500,000. So my guess, it's probably around the same, right? And then this is for you, Audrey. How hard or easy is it to get a work visa in Italy?
Oh no. Unfortunately, Italy is a beautiful country with not the best immigration system. So it is fairly difficult to get a work visa in Italy. You would have to have a company there to sponsor you. There's no lottery, so there's that. But it is a fairly slow process, and each kind of area in Italy, it is not federally administrated. It is, you know, so you might have drastically different processing times in Rome versus Milan. I would say probably on average, it would take about 4 months, 3 to 4 months to get the work permit that you need. Then you have to go to the Italian consulate to get your visa stamp. That will take a while as well. And then once you arrive in Italy, you have about a gazillion steps to go through for all your local registrations, your town hall registration. It's fairly ridiculous, but you know, it is possible if you have a company there that will sponsor you. At least you know, you don't have to win a lottery to do it. You just have to be patient, have several months of time, and not be put off by a lot of bureaucracy.
Okay, Audrey, I have an employee and they didn't make it the H-1B lottery and their work permit's going to expire, you know, in June, right? Where can I send them? I don't have any companies overseas. Like I just have this. I just have my US company. What's the fastest way I can get them somewhere so they could start working for me remotely in June?
Yeah, I mean, I think probably Mexico or Bahamas, Charina. Like,
Okay, so that's an option. So they'll
two
reach
of the
out to
easiest.
you. Okay, so I'm gonna send them over to you and then
Yes.
park them in some beautiful beach in the Bahamas or
Yeah.
Mexico.
They'll be happy. You'll retain them forever. They'll be on the beach. Everyone will be happy.
So at least there's an option. I think that's good to know because I think a lot of people are in despair many times when they just don't know where they can put their employee for a year. Of course, you have to think about what Audrey said about the challenges of living in another country for a year that you're not familiar with, right? But maybe the Bahamas isn't so bad, or Mexico. Yeah.
And one other just word of caution with the digital nomad visas, because they've been very fashionable and in the news a lot, but you do have to kind of dig into, in practice, is it actually working? We know of many countries where they've announced digital nomad programs, but then when you actually go to file an application, it's not functional. We're even having problems right now with Spain. They've announced a digital nomad visa, and because of issues with the tax office, we're not actually able to get approvals yet. So you've got to dig a little bit deeper than kind of the headlines and what you're finding on Google to make sure that it is a viable option before you make a lot of plans.
Yeah. Well, thank you. We've hit our time. I want to thank my clients who also and gave me a nice shout out in the Q&A. So thank you, Audrey, for joining us. And again, we will send out the PowerPoint, and then also there will be a recording on our YouTube channel. So thank you, everyone, for joining us. And please reach out if you have any questions.
Thank you.
Thank you.